here's a very typical business for a well-designed family. Well, the family's poorly designed, but their business is well-designed. So you have spouse 1 and spouse 2, and you see what a mess this is. They're out of order. And spouse 2 has a revocable trust, which owns 30% of a real estate LLC. Spouse 1's revocable trust has 40%, trust for the children, and spouse 2 have 30%. So spouse 1 has put 30% into this trust for the children and spouse 2. That's absolutely creditor protected. If spouse 2 gets sued, they can only get a charging order against 30%. If spouse 1 gets sued, they only get a charging order for the 40%. And if spouse 2 dies, that revocable trust on the left becomes irrevocable, and that's held for the health, education, and maintenance of spouse 1. Spouse 1's creditors can't get it, next spouse can't get it, IRS can't get it, SEC can't get it, Department of Justice can't get it. Now, the business we divide in this one into 3 companies, or 4. We've got the real estate on the bottom left. We've got a long-term lease agreement. That word licensing agreement should say long-term lease agreement. Then you've got the family, the main business operation, and then we put the intellectual property into a separate S-corp. So it pays royalties to that S-corp, and then the S-corp pays 70% of its money to a trust for the children that can pay for their college if they behave. And then we have a management company, which is a C-corp, receiving management fees and being taxed at a lower bracket. Now, if properly put together, that might be what Kevin calls the 1202 company. I have an article on 1202 companies. And but if you have a 1202 company, the money it receives has to be put into solid business assets, which might be leased or might be used by the business. But that's a typical scenario.